Assalamualaikum warahmatullahi wabarakatuh to Professor Suhaidi and fellow friends. Okay, today we will be discuss about a topic which is given by Professor Personal Data Protection Issue and Challenges. Before we are going more deep discussions about these topics, so we look what is personal data, the definition of personal data. Okay, the definition in the Data Protection Act, it means personal data means data relating to a living individual who is or can be identified either from the data or from the data in conjunction with other information that it is or it's likely to come into the possession of the data controller. So there are so many data protection privacy issues to watch in 2016, such as data localizations law, internet things, and ubiquitous computing. The PCC awakens government surveillance encryptions, the development of cybersecurity standards, regulating flexing enforcement power on data protections and privacy issues. And then what's more, we have a new translating data transfers framework, class action, statutory standing and spoken decisions, the EU General Data Protection Regulation, new translating data transfer framework issues and challenges. But today I will focusing on the personal data protection in employment, which is a new legal challenge for Malaysia. Okay, I will focusing on Malaysia. Here I will give some introduction about the Personal Data Protection Act in Malaysia 2010. Employee data are kept by employer either for the human resources management or to fulfill legal requirement of employment or society security legislation. Previously, the processing of this data is performed without much legal guidance or authorizations. However, the introduction of the Pdpa in 2010, data storage processes are now more regulated. Number 2, contract of employment and personal data. The theoretical framework of personal data protection can be developed from the performance duty of parties under contract of employment. A contract employment contains terms and conditions and obligation which party must perform based on the principle of good faith, fidelity and loyalty by Deakin and Morris 1998. A violation of those terms, conditions and obligation will result in a breach of contract and consequently a suit filed by the aggrieved party in the civil court. Thus, court's decision can form the basis of developing a theoretical framework of the duty to protect the employee's personal data. Number 3, right to the privacy under Malaysian law. Can the right to privacy be reconciled with personal data protection law? Privacy law in Malaysia is in a state of uncertainty. For many years, privacy law has been unclear in Malaysia, to the extent that some quarters are of the opinion that there is no such law in this country. Case law shows that judges are divided as to whether privacy law exists in Malaysia. What is clear is that there is no legislation in Malaysia on privacy law. Number 4, the Personal Data Protection Act 2010. The formulation of the personal data protection legislation started in 1998, and the first draft of the Pdpa was prepared and released for the public consultations in 1999 to 2000 by Azmi 2002. The bill was later redrafted in 2003 to take into consideration feedback from public comments and the evolving global trend in data privacy and personal data protection. The purpose of Pdpa Act is to regulate the collection, holding, processing, or use of personal data by any person to provide protection to an individual personal data by any person to provide protection to an individual personal data and safeguard the privacy interests of such individual. Personal Data Protection Act of 2010 and its relation to employment. Section 4 of the Act defines personal data as any information relating to commercial transactions, which make appear that the Act only applies to data related to a commercial transaction. A commercial transaction in this text is defined as any transaction of commercial nature, whether contractual or not, which include any matters relating to the supply or exchange of goods or services, agencies, investment, financings, banking, and insurance. In this respect, the Act is easily extended to employment as the word services in that sections refer to the employment. It is material whether the contract entered into between the parties is contract of services or contract for services. Under both categories of contract, the employer are duty bound to manage the personal data of individual or employees according to the Pdpa Act. Exempted in certain employment sector, these employers do not have a legal responsibility to manage their employees' personal data according to the 2010 Act. The Act completely exempted the federal and the state government from its application. It should be mentioned that the Malaysian practices federalism, meaning that the federal and state government have separate legal and governance authorities. Data Protection Principle in the PDP Act 2010 and its relation to employment. General Principle. Consent of the employee is the fundamental element. He or she must give his or her consent before any personal data about him can be divulged by the employer or management. What does consent mean here? Does it mean express consent or can it include constructive consent? This distinction creates a debate issues. However, it is argued that if the employee has been informed of the disclosure of his personal data and he does not object, then he has given his consent. Right of the employees as data subject. The right provided by the PDP Act 2010 to employees correspondent to the data protection principle examined above. The employer's duty to implement such principle is at the same time the employee's right pertaining to his or her data. The 2010 Act laid down the following right for employees. Number 1, employees shall have right to access to their personal data. This is in line the employer's duty under principle above. However, a question that might arise is, will the employer allow the office file, although it is about all the personal data matters of the employees, to be accessed by the employees? The meaning of the access here should be clearly defined by the Act. It is argued that the employees does not have the right to examine the file data digitally or manually, and that he or she can only request to be given the personal data. Of course, management has to ensure that the data are correct. Number 5, sensitive personal data in connection with employment. Obligation and the right pertaining to the employment have a special place under the Act. Employees' information may be considered sensitive personal data. Sensitive personal data refer to any personal data consisting of information on the physical or mental health or condition of a data subject, his political opinion, his religious belief, or information related to his offences. This information is retained by the employer management in the employment record. For sensitive personal data, the general principle requires that the data user or the employer shall not process sensitive personal data except in accordance with Section 14. The explicit consent of the employee is required before the data can be processed. Number 6, recourse by an employee for an employer breach of confidentiality. Under employment law, parties are subject to the terms and conditions of their services contract, signed by Deakin and Morris in 1988. a breach of any terms or conditions expressed or implied of the contract by one party will entitle the other parties to initiate legal action, said Hassan in 2007. In the event that the employer breached the confidentiality of the employee personal data, the employee will have recourse to such action, said by Hassan in 2009. Although few services contracts especially state that employee is under a duty to maintain the confidentiality of employee personal data, the implied term suggests this duty and the employee may take actions under this term. Okay, last but not least, the conclusions that can be made from this discussion, okay, show that the promulgation of the new legislations, management or the employer has an added duty to ensure the proper management of the employee's personal data. Management as the data user is bound under the Pdpa to safeguard employees' data accordingly to the Act. Likely, the employee as the data subjects enjoys some right under legislation. The 2010 Act has certainly reinforced privacy law in Malaysia, which was not very clear. The new legalization will certainly be challenged for employer and management who now have an added duty to ensure all of the principles of the new acts are followed. However, as with any other legislations, enforcing the act is a challenging part. Thank you.